So hello, and thank you for joining us for today's webinar, a critical look at the IDEA due process hearing system and suggested improvements with Doctors David Bateman and Mitchell Yell. I'm Dr. Melanie Reese, Director of CADRE, and I'm joined by our CADRE staff, Noella Bernal, Kelly Rauscher, and Manny Gwendolay. This webinar is being translated simultaneously into Spanish and into American Sign Language. To access the accessibility features, please follow these instructions. A few technical notes. All lines are currently muted. Please post questions in the question box if you have them. I will be collecting the questions and will share them with the presenters as the time allows. And at the end of the session, they've saved some time for questions as well. And we thank you so much in advance for taking time to respond to a very brief survey at the end of the presentation. Your feedback is incredibly important to us at CADRE and our ability to continue to bring you webinars such as this one. And finally, this webinar will be posted and archived on CADRE's website. Here's our standard legal disclaimer. The information that we're sharing in this webinar is not intended to serve as, nor should it replace any legal advice. Opinions expressed by today's presenters are not represented to be an official or unofficial interpretation of any legal guidance from the U.S. Department of Education or CADRE, and application of any information presented may be affected by your state statutes, regulations, local policies, and practices. The information that is presented is the presenter's own opinions. So with that, just to let you know that we were so excited to present this presentation. The presentation was born out of a conversation with Dr. Bateman last fall around frustrations with the due process complaint system. While recognizing its critical role in dispute resolution options available under IDEA, we saw, shall I say, opportunities for improving the system. And the more that Dr. Bateman spoke, both from an academic viewpoint and as a former hearing officer, the more it became apparent that this really should be a national conversation. And in the spirit of getting that conversation started, CADRE is very excited to bring you our two esteemed presenters today, Doctors David Bateman and Dr. Mitchell Yell. They each will share a bit of their background with you in a moment, but I want to lay the foundation for you all by saying this is an honor to introduce you to these two influential voices in our field. I have several books on my shelf of Professor Bateman's, and I look forward to his forthcoming Special Education Leadership, Building Effective Programming in Schools. And likewise, Professor Yell is a nationally recognized expert in special education law and IEP development with many publications on special education policy and practice, special education law, and IEP development. And I'm going to stop there and just say welcome to our forum and welcome Dr. Bateman and Dr. Yell.
Thank you.
Thank you very much for that wonderful introduction. And I do want to make sure that everyone does understand that when Dr. Reese and I sat down at the case conference in Pittsburgh, we very quickly went to a wonderful discussion about the problems with the system as it is currently exists. And I think we mind melded on a number of issues, and it was truly a very, very pleasant experience. And Dr. Yell and I have authored a number of books. We are not here to sell you books, and we're not going to even push or advertise any of the books, but just to remind you that if you're looking for a good Halloween thing to pass out to your neighborhood, our books make great gifts, and you will be the talk of the neighborhood. So just to give you the heads up on that. So just keep that in mind as you talk about this. So yes, we're going to talk broadly about this and I'm just going to explain how we divided this up after we give the official next page disclaimer. Dr. Reese has already given you a disclaimer, but we also need to give a disclaimer because we just want to make sure the views we are going to express here are not of they are solely of our presenters, and we've talked about these. They do not necessarily reflect the views of our employers. Our employers are wonderful, but we want to make sure that we're not representing them as a part of this. And because I now no longer work for university, I now work for AIR. And there's some interesting parts about this. So let me just real quickly introduce you to myself, just so that you understand the perspective that I bring to this. And so you understand where I am on this. I come from a family of educators. My dad was my superintendent of schools, and he was just recently the executive director of the Urban Superintendents Association of America. So education is what we do in our family. My daughter is a special education teacher. My wife is now in education, so it's what we do. But I was a classroom special education teacher for a number of years. I thoroughly enjoyed it, and would go back if I could just do it like Monday, Wednesday, Friday for a few hours each day. But I enjoyed being a teacher and I enjoyed working to provide services. But I was also a building level administrator, supervising services for kids and helping provide what's going on. And I say this because I do a lot of writing about principals, and you'll hear more about that in a minute. But I would go and dutifully every Sunday night, make a list of what I wanted to do during the course of the week, and then have to respond to everything during the course of the week. I'd write the same list every Sunday, but it was just trying to get things done because it was very responsive. I was having to respond to things and couldn't be proactive. I was a professor in Pennsylvania for 28 years and enjoyed that, and just recently retired from that, and now moved away from that in Pennsylvania. But when I was in Pennsylvania, then I was a first-tier due process hearing officer. Did that for a decade. Pennsylvania is a litigious state, and was part of the process at the Office of Dispute Resolution, a wonderful service run by an amazingly individual, Carrie Smith, who does great work there. And I was really impressed with what they do and what they're trying to do there. So I had a nice time working there. I currently now work for the American Institutes for Research. I'm a principal researcher, helping with, I'll share with that in a minute, but helping on a lot of things relating to policy and legal issues and helping them just kind of move forward as it relates to special education knowledge. Really enjoying my time at AIR and helping with this. I'm also a second-tier hearing officer for the great state of South Carolina. And we'll talk about the needs that they have in a minute as a part of this. And I'm an author of multiple books. Mitch and I, we have a series at Rowman and Littlefield on public policy and special education law issues, which we're coming up on. I think by the end of this next year, we should have 33 books in that series. So we're proud of where we are with this, and we're proud of what we do with this. Let me just give you a little more background about me. So I have some other things that I do as part of the next two slides. The next slide is information relating to the new OSEP-funded center on working with building administrators and principals relating to special education. I'm one of the co-principal investigators of what's called LEAD IDEA. It's OSEP's new big center. You're going to hear a lot about this over the next couple of years because it's a 5-year project. We just started just a few months ago, but you're going to hear about this. We do not have we have a placeholder URL, but we should have a new URL for this in the next week or two. But we're really excited that OSEP is putting money behind this effort to provide important information relating to special education for principals, because as we all know, the principals are the leaders of the buildings. But 1/4 of all principals change nationwide each year. And many principals do not receive any training or pre-service introduction information relating to special education services. But what we're going to be doing, and we have a great team as a part of this, is to develop the competencies for pre-service, but also have come up with some leading learning modules that will help with this. And then the next slide, as we talk about this, is just I lead AIR's program review efforts. We do audits of LEAs and SEAs, our program reviews, to help them understand what they can do to do better. We've done in districts as small as, I think, 1,000 students. And then we have them, I think it was 900 students. And we also did one in Fairfax County, Virginia, which is one of I think the 10th largest school district in the nation, which has, I think, 29,000 students eligible for special education. So a very large district. So we have quite a range, and we're doing multiples right now. But I lead those efforts and help part of this with a great colleague, Laura Kukli, we're running this together and having a wonderful time putting this, okay? But this is just background on what I do, and I'm going to turn it over to Mitch, who's going to give you some information about himself. He's muted.
Sorry, I have a dog and two little granddaughters that are talking and barking, so I'm muting ever so often. At any rate, my name is Mitch Yale. I'm a professor at the University of South Carolina and former special ed teacher from Anoka-Hennepin, Minnesota. I was administrator for a little time, although I tend to try and avoid administrative work as much as possible. I also did IEP facilitation in South Carolina, and I have been an expert witness for hearings in cases both that were brought by the school district and brought by parents. Currently, like I said, I'm the Fred and Frances Palmetto Chair of Teacher Education and Professor of Special Education at the University of South Carolina. I also am a state review officer for South Carolina. Of course, South Carolina is one of the few states left of the two-tier due process hearing system. And finally, I am also the policy chair for the Council for Exceptional Children, and I noticed Angie Balsley, who is the policy chair for the Council of Administrators of Special Ed, her case is here today. So do quite a bit of work on policy in that area. I also have been in the last few years special education expert in two discrimination cases against school districts brought by the Department of Justice under the Title II of the Americans with Disabilities Act, which has influenced my thinking about the due process hearing system and the idea. Okay, and now that's me, and I'll flip her back to David.
Thanks, Mitch. So we're going to divide this presentation into two very distinct halves. And I don't want to refer to it as, I've referred to it as bad cop, good cop, but it's a little bit more than that. We're going to talk about the problems with the due process hearing system. And I'm betting that many of you who are attending today could probably come up with these, but I'm just going to try to articulate them in an understanding order for those who may not really be familiar with the process and understand this. And then, but also then I'm basically I get to complain. This is one of the best gigs, Dr. So I appreciate the opportunity that Dr. Reese, I have this opportunity just to complain. I will take it, but really articulate the problems so that others can understand this and take this back to their team so they truly understand. Then I'll turn it over to Mitch, who will talk about suggestions for improvement. Then we have some additional recommendations and hopefully have some opportunity to take questions. So that's where we're going this. Okay. So let's turn to the next slide. First, I just want to make sure we are not anti-due process hearing. I just want to make sure we get this out. I get calls from parents all the time seeking how to go to a due process hearing. I try to talk them off the ledge, but sometimes it needs to be necessary. And I know there's some historical reasons why we need this. And there's some historical reasons why we understand this. And I'm just going to give you a personal story on this one. My brother-in-law is labeled as having profound intellectual disabilities. And for the first 17 years of his life, he was legally denied access to education because he's now in his mid upper 60s. And so it prevented him from participating. He was actually, he got actually 1 year of education. And he's nonverbal, needs help toileting. He knows maybe six signs, of which most of them relate to going to McDonald's right now. But it's interesting about this is we need an opportunity for parents to challenge this. Because I've written on for administrators, I've written for school boards. And when we talk about this, I do a lot of presentations for school boards, and there's many school board members who will come to me who do not want to provide services. They just view individuals eligible for special education as, for lack of a better term, money sucks. And that they don't want to do this because they see that I get the question all the time. Why should we be paying this much for a kid who's not going to generate taxes? And so I get that, and it's an interesting part of this process. So we want to make sure that we have an understanding is that these individuals have disabilities at no fault of their own. And what we have to do is what we can provide services. But we need a system. We need a system that helps understand this, that can challenge what's going on. Because as the law very specifically says, we have to provide an appropriate education. Appropriate is very much in the eye of the beholder. And that's what we have to think about as a part of this. What I might view as appropriate may not be appropriate for others. And we've had 2 Supreme Court cases on this that helped clarify this. And I wish for a little bit more guidance from them, but we'll take what we've got. But it's interesting about this is we need a system to help on this. What we also have to reiterate is that there are other mechanisms for alternate dispute that we need to pay attention to. The due process should not be the first avenue that we go to. And it should not be the way that we do this and should not be our focus. But that's what we're going to be talking about because that's what's on everyone's primary agenda, things like this. So let me tell you about let me move to the next slide and talk about just basically the problems. I now live in the fair state of the Commonwealth of Virginia. I grew up here, went to school here, moved away for several decades, but now back here. These are statistics from Virginia. And I just want to make sure that people understand. If you look at these statistics, and these are I did not put this graph together because it involves color. I can't do that at the same time. I'm not that multi-talented. But what's interesting about this, you can see the due process hearings that ruled fully in favor of parents. This is district and over close to 1,400 hearings from 2003 to 2021. You can see it was only 1.8%. And that's the big statistic that's been out there about this. So, and you can see where we are with this. Now, what we don't often pay attention to is you can see this from the top, the 47% that are withdrawn or the 12% that are settled. That's close to 60% of all due process hearings, which is consistent with the number of hearings that I've been involved in that have been withdrawn or settled. But we don't report on those. The vast majority of hearings are withdrawn or settled because of the issues are either we can come to a very quick agreement, it's an issue that shouldn't be litigated, or the district has realized, oh, we've really messed up. We really need to get this off our plate real fast. So we don't talk about this as a part of our numbers. But I looked at this in the year before COVID, and I haven't kept good data on this because COVID messed up everything. But is the year before COVID, I was involved in 93 due process hearings, working on consulting on those. 79 of those we settled very quickly. And we only moved forward on 14 of them. 6 of those settled within about a month afterwards. But it was really interesting. We don't only report on those final 8 that went to hearing. So it looks like there were only 8 due process hearings that were going on when there were really over 90. And we had to do a lot of preparation. So there are problems with the reportings on this. There are problems with the system, and there are problems with how we talk about this. So what we're going to do here today is try to talk about the problems, but also to address this in ways that can fully understand how to articulate this so others can pay attention and be aware there with us. So, all right. So the next slide is I'm just going to start talking about the problems. Okay. The cost of legal representation and expert witnesses. It really poses a problem because there are some law firms that I have worked with where they have a $4,000 or $5,000 retainer for parents to just even look at the files. And they have a very good former director of special education who's been hired by the parent attorneys to look at the files and go through this, what's going on. A lot of parents do not have $4,000 or $5,000 extra dollars just laying around that they can have that as a part of this process. We often think about this, but it is something that is necessary, but we have to think about, can that really adequately represent parents as a part of this? And can we really truly understand what's going on about this? And in many places, expert witness fees are not allowed to be reimbursed. So that's something that's born out of the other part of the process. And has someone who serves as an expert witness and has served as an expert witness in some cases, I know that the bike mechanic at my local bike shop gets paid more to do bike repairs. And as a certified bike mechanic, I can vouch for this. Yes, I did go to the school in Colorado Springs for it. Is that they get paid better than expert witness fees often in due process hearings. And so I just want to make sure that we are aware of this and talk about this. So the next slide, and we just hit this on this next slide, is that there are some places where how does hiring a no-win, no-fee attorney work? There are not many people who will do this. There are not many attorneys who will take this on a no-win, no-fee kind of process. So it poses a problem. Yes, I just copied this from the Google, but it's interesting about this is we often have to think about the cost of this, and we don't talk about this. And it is an intimidating process. And that's why we have to think about this. Because as we're about to get into the problems with the process and the problems that we have in trying to move this process forward, it does pose some different things. So let's go to the next slide and just talk about parents and their reluctance to initiate disputes. Okay? Well, this make sure that you understand. We pass out procedural safeguards notices to parents like candy. And when they sign the IEP, when they come to the IEP, when they agree on a placement, we pass them out like things like this. But they say it's interesting. It poses a problem for parents as they don't often read this. But many parents are not aware of their legal rights, of their specific entitlements under the IDEA. So there's additional fear of straining relationships with the very educators and administrators who are integral to their child's daily learning experiences. This is an important part of the process. I was a hearing officer one time where the parents representing themselves made the teacher cry because they were questioning the teacher's professionalism. And that teacher was done testifying by 11:30 in the morning, but then had to walk down the hall to provide education to that child. And so it was really interesting about this process. That teacher resigned about 3 weeks later. So we have to think about this. The parents are often worried about initiating a dispute that could lead to negative repercussions for their child, because we're basically suing these people. And many of the questions that we ask as part of witness preparation relate to the professionalism that these professionals bring to this. Do they have the qualifications? Where did they get their training? And there's people who often get very defensive about this, and it poses a significant problem. But we have to remember, we have to work on this and play along with this, because some of these kids are going to be going to school for 12, 15 years in these school districts. So we have to think about the process as a part of this. The next slide, okay, is time constraints, okay? The process for actually preparing for a special education due process hearing is incredibly time consuming. It involves gathering documents, it involves meeting with attorneys, and potentially attending many, 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 many meetings. For working parents or those with other children, this can be a daunting commitment. And not sure exactly how long a hearing will be or when that will actually next ones will occur. Balancing these demands with the everyday demands of their needs of their family, especially a child with special needs, it can be extremely challenging. So parents often shy away from this process because they're going to go through many days of not only just prep, but then multiple days of the hearing, and then to then have to wait for a decision. And so it's an interesting part of this process that the time constraints of this are often very painful. And we need to realize the process and make sure that we understand this and explain to parents fully what they're expecting as a part of this. Move to the next slide, okay? And the complexity of the hearings, right? Luckily, I had a background where I'd taken on multiple classes in law school that helped me understand the legal process of this. And then I had a background as a special education teacher, but special education hearings involve a blend of legal and educational concepts that can be difficult for any layperson to understand. I mean, just think about it, the nuances of an educational policies, the nuances of an IEP, the specific legal requirements require expertise that many parents just do not have. And we're also finding that there are increasingly attorneys who do not have this. And attorneys don't have to have special education knowledge about this. And so it's one of my last cases I did in Pennsylvania last year was involved an attorney who was very good with taxes, incredibly. In fact, that attorney's picture is on multiple billboards advertising tax services, but didn't know anything about special ed, so did not understand the difference between an LRE and an ESY. And we have a lot of acronyms. We'll get to that in a minute. But so as to accurately reflect this information can be difficult for parents to understand this and be able to advocate effectively for their kids, because there's a lot of nuances we have to think about this. Moving on to the next slide. This builds on the other one. The legal proceedings can take months and just to get ready for a due process hearing. Yes, we have very specific timelines for due process hearings, but once it leaves the due process hearing, it can take years for these things. I'm involved in a court case in one of your states out there that is, it's been, I think the former term is dragging on for a long time. And so it's been going on for a long time. The financial burden of these disputes, including the attorney's fees, the cost for expert witnesses, the potential loss of income due to time taken off for work, and taking your vacation days to go to a hearing instead of doing other things that might give you actually relief. It can be overwhelming for families, particularly those with limited financial resources. It's not a system that is set up for parents who are working and have jobs where they can't take off on a moment's notice or take extended time off these. It poses a significant problem for this, and it makes it very difficult for parents to really participate in the process. And we've got to remind ourselves of this. And it's not that the parents don't want to participate; it's just that they don't have the time, and they're worried truly about this. Next slide: the adversarial nature of this. We swear in witnesses. People are testing under oath, and I don't like testifying under oath because I often don't sleep well at that night when I do testify, because I say, I should have said it this way, or why did I say this word, things like this, or it's misconstrued. When I write, I edit and make myself look pretty the next day. But when you're testifying, it makes it very difficult. But it's adversarial. You're sitting on two often very different sides of the table with your team, and there's no commingling between the teams, things like this. The inherently confrontational nature of legal disputes can create a very hostile environment. This can be actually especially distressing for parents who are already dealing with the emotional and logistical needs of raising a child who has special needs. But they see themselves on one side of the team, and it's the IEP. The intent and spirit of an IEP is it's a team process. But then when we go to a due process hearing, you have everyone who's probably part of your child's IEP team sitting on a different side of the table, conferring without you and talking about what's going on. It poses a significant problem to where we are with this. And so what we have to think about is, what can we do to reduce that kind of adversarialness that's a part of this process? Because I mean, some of these kids they're going to be in the districts for years. And we're going to have to get along and play along and work with these parents and spend time with these parents, interact with these parents in grocery stores, interact with these parents at back to school events, after school things. We need to understand this. But the adversarial nature is often a neglected part of this process. But by nature, it's adversarial because you basically have filed a lawsuit, and lawsuits by nature are adversarial. Moving on to the next one, the emotional impact of this. Right? This stress. And I don't want to talk lightly about this. So just expand whatever I'm saying and multiply it. But the stress of engaging in a legal battle over a child's education can take a significant emotional toll on parents. We can talk about the significant emotional toll it takes on professionals also, but on parents, it involves not just fighting for services or accommodations for a child, but also defending their child's abilities and needs and making sure that those are being fully addressed. This emotional labor is an added burden to the already challenging role of parents a child have with special needs. I mean, my wife grew up with an older brother who had a significant disability, who then they never went out to eat. They never got respite care and things like this. They never went to places. They couldn't, because at the time, this is before ADA. There are many places would say, do not bring his type here. And so it posed a significant problem. So parents don't often get a break on this and the emotional impact. They couldn't get babysitters. They couldn't get other care. So we talk about this as a problem, and we need to think about this. It's not just the emotional impact, but some of these, as my wife and I went to my brother-in-law's service plan meeting last week, the family needs continue well after the individual leaves K-12 education. So we have to understand this and emphasize this and pay attention to this. Next, the educational disparities that exist and the issues. I'm not going to say anything you don't know, but I'm just going to break this down into terms that we hopefully all understand a little better. But socioeconomic status and educational background greatly influence a parent's ability to engage in these disputes. And there are some states, if you look at the numbers, there are some states where there's more litigation than others. And you can look at some of these states as everyone just getting along just fine. Well, I'm not sure if that's the case. Lower income families may lack access to resources such as legal representation or educational advocates. There are some of our states where there are very few attorneys representing parents in these disputes. And so we have to think about this is it really an equal playing field? Okay? And then it's also parents with limited education may find the process particularly daunting, further exacerbating educational inequalities. And so we have to think about this one and pay attention to as we address the needs and address the issues as we pay attention to this, because it can cause some severe problems for these parents. Okay. Next one. Barriers to enforcement. Barriers to enforcement. Okay. Prevailing in a special education dispute is only one part of the challenge. And you think that you've got everything. Ensuring that the school district actually implements the agreed upon services and accommodations can be another hurdle for parents. And that's something that we often forget about this. You think if you can prevail, you've got the hearing officer's ruling, everything's going to be fine. That's not necessarily the case. There can be resistance or delays from the school districts. They often require parents to be vigilant and sometimes engage in further legal action to enforce compliance. It shouldn't be this way. It shouldn't be. And I say this because when I said we are not fans of due process hearings, we're not anti-due process. We're not fans of this. But we wish there was a world where we didn't need due process hearings to enforce the rights that these kids, as I said just a few minutes ago, who have disabilities at no fault of their own, need additional services. And so we have to think about this and talk about this and address this and make sure that we have this. Next, limited accessibility. Accessibility challenges extend beyond physical barriers. We got to remind ourselves of this, okay? For parents who do not speak English as their first language, navigating the legal system and educational jargon can be particularly daunting. It can be incredibly tough. Additionally, parents with disabilities may face their own set of challenging and accessing these proceedings. So we just have to think about the fact as we in the United States are, there are many different cultures, there are many different languages, and what we have to think about, how can we get all of these individuals to participate and be part of the process so that we can fully engage and have opportunities for them to be part of the team for their child. Which brings me to the last one. Right? And this one was put in purposefully by a team that I'm working on in Michigan, but just the ALJ's lack of understanding of special education acronyms. And I can go on acronyms for a long time. I do a lot of trainings for individuals from the lead IDEA Center. I do a lot of trainings for principals, a lot of trainings for school board members, and I can spout off acronyms. In fact, I often do. That the child needs an IEP that we're implementing in the LRE based on the IQ scores from the WISC, the WOJO, and that we provide appropriate ESY progress monitoring data that can help make sure that we get services in the IHOP. And we do these. We spout all of these. We can spout these acronyms. For those of you who understand what I said, that's great. That's really good. I only added IHOP at the end because I'm hungry. I haven't had lunch yet. But it's interesting about this is we can befuddle people with acronyms. We can overwhelm this. But the language that we use in this is not something that's familiar to administrative law judges who may not specialize in education law. There are parents who don't understand this. It's not just ALJs. I'm just picking on ALJs here because there's some really good ALJs out there doing wonderful work, and I appreciate all that they do. But we have to make sure that we have a full understanding of what we can do to provide appropriate services and make sure that people understand what we are doing as a part of this. But it poses problems, just the language we use. I mean, I had a parent about to testify in a due process hearing and turned to the other parent and said, "What is this Dibbles thing? Is this the name of the mouse or the pet mouse in the cat in the classroom or what?" And so we use a lot of acronyms, and it poses a problem for people to really fully understand what's going on. But it's a language that we're comfortable with, but we need to make sure that others are also. So there's a lot of problems, and I've highlighted a lot of problems. I could go on for a while, but what I'm going to do is I'm going to turn it over to Mitch, who's going to come up with some recommendations and try to clarify some things that can provide additional supports.
Hey, thank you, David. Next, just go. I'm going to talk about some recommendations, and I have a few questions I've kind of posed to myself. And one is, was the dispute resolution system of the idea ever intended to be so adversarial and legalistic? And if you read the language in the regulation and the statute, the way it was set up, it would be difficult to see how you could avoid that. But the answer is probably not. On the next slide, actually has a quotation from Joe Ballard. Joe worked with the CEC, along with Fred Weintraub and Alan Abelson, and Hill staffers, Lisa Walker, Martin Lavore, and Duncan. And they worked together in starting the Educate for All Handicapped Children Act. And they did want to protect students with disabilities from arbitrary and ill-conceived school district decision-making. And they did give parents a number of procedural rights to exercise on behalf of their children. But and of course, one of these procedural rights, if they were not successful, then a due process hearing came into play. But according to Ballard, the original authors never really intended for the due process hearing to be so legalistic and adversarial. And when he was asked in a 2008 textbook by Kurt Hewlett, Kurt started the introduction, I should say, to his textbook was an interview with Joe Ballard, one of the final interviews I believe he did back in 2003. And Kurt had asked him, what is the most unintended outcome that you've seen in this law? And basically what he said is we had intended that disagreements on the IEP process would be resolved in a reasonable manner by persons who had the background to make informed instructional decisions. And due process was never intended to be confrontational like it is now. We didn't want it to be so highly legalized. We didn't want it populated by lawyers throughout the administrative due process. And we just never intended that the due process hearing would really evolve into an administrative law courts. In fact, he said at the time there were judges that were encouraging them to settle disputes in non-judicial resolution settings. And that's what he said the original safeguards were really about, not about the adversarial and legalistic nature. But in the next slide, we see another question, which is the dispute resolution system of the idea, is it cumbersome? Is it inefficient and too procedural? Yeah, it probably is. If you go to the next slide, and David talked about a lot of these problems. So probably so. They very much due process hearings very much are a problem. Now, one of the things I did to prepare for this was talk to some really good advocates that I know, and also talk with some due process hearing officers, but LEA officials who have been involved, and ask them about what kind of problems do you perceive in due process hearings in the current way that they're done. And the answers, surprisingly, were very similar. Now, when we looked at the problems identified by the advocates, they said, well, it's too legalistic. They would say things like, we need to make assistance available to pro se parents. Specifically, one advocate talked about how often they see notices of insufficiency. And parents just aren't really, especially pro se parents, are not able to handle those. Now, the second problem identified was that the system was just too adversarial. As David is well articulated, the due process system is not really a level playing field. For instance, one advocate told me about the problem of expert fees. In due process hearings, the educators are often considered the experts, or they bring on their own experts, and that isn't available to a lot of parents. So it really is not a level playing field. Also, advocates mentioned the too short a decision time between the resolution meeting and the hearing or decision, which just does not give them enough preparation. And finally, advocates were mentioned. So often hearing officers just are not trained in the substantive requirements of the idea. They understand the procedures, but they just don't understand an IEP that well and the substantive issues. Now, in the next slide, you'll see the same problems being identified by the LEA officials. System is too legalistic. It takes a huge amount of time and resources away from a school district, time that could be spent teaching, where folks like David are out preparing teachers for testimony. They're unable to teach. They have to get substitutes. A number of LEA officials. Now, I am from South Carolina, and we have a two-tier system. A number of LEA officials wondered why. Why do we need a two-tier system? Also, the due process hearing system is just too adversarial, which really severs or harms any opportunity of a working school-parent relationship. Also, it's very stressful for teachers and administrators. As I'll be talking about in a little while is one association did a survey of 200 superintendents across the country. Fully 95% said this is either very stressful or really stressful to teachers and administrators who have to testify. LEA officials also mentioned the problem of too many complaints, sometimes by certain parties just filing complaint after complaint after complaint. And David alluded to this, and I just talked to attorneys, advocacy attorneys in Iowa, where they had 3 teachers who had worked with this. The advocate had been on the IEP team. They resigned. So it can really contribute to teachers leaving the profession. And additionally, LEA officials also noted that hearing officers should be trained in the substantive requirements of the idea. Now, in the next slide, we see there was a suggestion common to advocates and LEA personnel alike, and it really is not the subject of this webinar, but I thought I'd bring it up at any rate, and that is that states should have some sort of certification or licensing requirement for special education advocates. And this for both sides, saying that there's a problem with many advocates who are not properly trained, who do not really understand the idea, who bring up procedural issues into the due process hearing. So and that was another concern, certainly mentioned by everyone. Just the suggestion that there be some sort of licensing requirement. One advocate actually told me her state has a licensure for manicurists, but none for special education advocates, and it's needed. So in the next slide, we see the next question. Can we fix the dispute resolution system? Well, there's a lot of possibilities. And what I thought we'd do in our few minutes remaining is talk about some of these responsibilities. And in the next slide, we see there's 3 basic models for change that I wanted to talk about. The 3 models, one was developed by the American Association of School Administrators. One was actually an old model that was addressed by Perry Zerkel a number of years ago. And the third thing I wanted to talk about is a dissertation written by Dr. Balsley at the University of Indiana, which was very interesting too. And all three really represented a model for changing our system that I would like to discuss. So first off, let's go on to the next slide, which there was a document issued by the American Association of School Administrators, which was titled Rethinking the Special Education Due Process System. And they identified many of the problems that David talked about. You know, the current system causes school districts to expend considerable resources and impedes the district's ability to provide enhanced academic experiences. Well, in terms of resources, we know it costs districts. I mean, they have to hire attorneys. It takes a lot of time away from teachers. Attorneys, of course, are very expensive. And although many school districts will have attorneys on retainer, and they'll have insurance for that, but it's still very expensive. So a considerable cost in resources, and it really hurts the educational process. Another problem that the American Association brought out was the lack of any evidence that students whose parents invoke due process hearings, do their children fare any better academically after a hearing? And the American Association said, really, there is no evidence of that. The cost and complexity of hearings hinder low and middle income parents in challenging a school district special education services. I know in South Carolina, we see certainly a lot of the hearings are pro se, where the parents are representing themselves, and they don't really have a good grasp of the issues they need to be raising. They'll talk about procedural issues, and often it may be because that's what they're advised to do by advocates who are less than qualified. But so the cost and complexity of hearings can hinder low and middle income parents. As Dave said, parents who have higher income, probably not an issue for them. But both parents and school district officials express satisfaction with the due process system, despite parents requesting the majority of hearings, and usually school districts prevailing. Both parties expressed quite a bit of dissatisfaction. And then finally, they said both parties and school district personnel are profoundly affected. As I said before, the American Association, what they did in this particular piece is they surveyed 200 randomly selected school superintendents, large, small, urban, rural school districts, suburban school district, and they asked them to describe the challenges faced by the district. And fully 95% of them said stress on their teachers or administrators from this system profoundly affects them and often leads to resignations from the field. So that's a problem. So what the American Association did in the next slide, you can see, is they came up with recommendations for improving the dispute resolution system. One of the first issues that the American Association brought up was the importance of adding IEP facilitation to the list of options available to school districts. Now, many states have IEP facilitation. It's not part of the federal law, though. The American Association suggested authorizing districts to contract with state-approved and trained IEP facilitators. So that's one of the recommendations, add IEP facilitation to the idea. If the second recommendation if a formal due process hearing is requested, mediation is requested, mediation should also be offered immediately. Now, of course, the mediation is optional, but they suggested that states provide trained mediators and not have attorneys or advocates at mediation sessions. Thirdly, they said if mediation fails, the district and parents would jointly select an independent, neutral special education consultant. This person, this consultant, would be designated by the state to review the situation in the dispute and advise the parties on how to develop a suitable compromise IEP. And they gave some real specific recommendations that the expert would be given 21 days to assess the situation, observe the student, look at the IEPs, write a report. Now, the idea would be both parties would jointly select this independent neutral special ed consultant, and both parties would be obligated to adhere to the requirements set forth by the consultant for a specific period of time. Then, if either party was dissatisfied, a lawsuit could be filed in state or federal court. Now, according to the American Association, there's some real advantages to this sort of system. One is it doesn't focus on the procedural, which often due process hearings do. It really focuses on the substantive issues. It emphasizes building a strong plan for improving academic and functional performance of a child. Secondly, it's based on evidence. The special ed consultant would have expertise in special ed, understand evidence-based practices. Third, it would level the playing field. This person would be selected by both parties independently. They would be approved by the state, and it would be no cost for the parents. Fourth is be a lot less stressful because no one is going before attorney and having to answer, or as David said, having your credentials questioned. So it's really less stressful, doesn't waste time. And fourthly, or fifth, I should say, it would greatly diminish adversarial relationships. So if we go to the next slide, we could see that what the American Association did here is in presenting this model. The top really represents the current IDEA model, where there's a complaint, optional mediation, the due process hearing is still filed, there will be a resolution session, a due process hearing and litigation. Now, in the American Association model, what they suggested is 1, begin with a facilitated IEP, 2, if that is not successful, and there is evidence brought up in their paper that this is facilitated IEPs can be very successful. But if it's not successful, then have the option for optional mediation. If that is not successful, then we would go to the consultant who would be appointed by jointly by the parents and the school district to work on improving the IEP, coming up with a compromise IEP. And then finally, if both parties would have a certain amount of time in which they'd have to adhere to that. And then finally, in a very few cases, hopefully litigation would still be present. Now, I did put the URL below this to the paper that was came out from the American Association. Very interesting model for changing the due process hearing system. Now, if we go to the next slide, back in 1994, Perry Zerkel wrote an article called Overdue Process. I can't remember what the exact name was, but overdue process revisions for the IDEA. Now, he said he agreed with many of these same problems. The due process system has become unduly time-consuming, open-ended. The process is over-adversarial. Costs are excessive, particularly in light of tight education budgets. The majority of cases that reach courts are about disputes like attorney's fees or maybe fact-based issues on a student's IEP, and really cannot be transferred or generalized as well. And also parents tend to view the process as unfair. So what Dr. Zerkel suggested, and then in the next slide, is that the next slide goes through his recommendations. And one of his recommendations was the due process system should be the final stage in most cases. The decision should be binding on both parties, with only a few cases that present a legal issue being reviewable by courts. And he suggested a model much like binding arbitration in labor law, where an arbitrator is appointed and arbitrates or comes up with a decision. And he also did mention that it should be single tier at the state level. Secondly, he said regulation should specify that the hearing officer has expertise in special education issues, substantive issues. And David and I were on a panel with Dr. Zerkel and Julie Weatherly and Jim Walsh a few years ago in Indiana. And that one of the things Jim Walsh said is he thought hearing officers needed to have expertise in special education. And then matters such as legal updates, decision writing, conducting a hearing, that could be addressed through training, but the substantive issues really can't be. So hearing officers should have expertise. He also said the conduct of the training would be in accordance with a problem-solving model rather than an adversarial model. That attorneys' fees would be limited only to the judicial stage, and that hearings should have a one-day limit. And the 45-day rule would for issuing the hearing decision would be strictly enforced. So now if we go on to the next slide, we see what we really have here is this type of model. Again, the IDEA model above, Perry's, Dr. Zerkel's model below. Now, Dr. Zerkel wrote this article before resolution session, so I kind of fit that in. But what he said is upon receiving a due process complaint, you go to optional mediation, resolution session, and then the due process hearing of 1 day with a hearing officer who has expertise in special education. And in a very few cases, there would be appeals. Now, this article is also available at the URL I listed on this page. And the last thing I want to talk about real briefly, and I'm not going to do it service justice, but Dr. Balsley in the next slide this is based on her dissertation, which I thought she did a fabulous job and has some really good suggestions. Problems are very similar to the ones we've talked about already. One of the things she said is that oftentimes requests for due process hearings come unexpectedly, and much of the problems that occur with due process hearings come right after the initial request. She also said many attorneys on school districts' sides discourage the use of mediation. Again, this is reports of school district special ed directors within her state. Most due hearing requests are settled, which according to Dr. Balsley indicates the use of alternative dispute resolution can be successful. She mentioned hearings are very resource intensive, extremely time consuming, and expensive. Huge emotional drain on principals, on teachers, on staff, harms the relationship that has to continue between school personnel and parents, and the presence of attorneys escalates conflict, strains relationships, increased litigation costs, and inhibits collaboration. Now, in the next slide, we see Dr. Balsley's recommendations. And she recommended using trained IEP facilitators to enhance communication. And of course, IEP facilitation is really about improving communications, ensure that mediators are well-trained in special education, limit the involvement of attorneys, and alternative dispute resolution systems should not be voluntary. Principals, teachers, staff, and parents should receive training on handling disputes, on conflict resolution. A special ed director should not only be trained in special ed law, they should have negotiating skills, they should be knowledgeable about organizational leadership. Some of the things that David talked about his lead idea center. And Dr. Balsley also suggested a tiered system of alternative dispute resolution before a hearing request may be filed. Now, if we go to the next slide, we see the suggestions of Dr. Balsley, and we have again the idea model, the current one above, and below we have her model, which would be beginning with a state complaint. Then there's required mediation. At that point, if that is not successful, that could lead to a due process hearing request, inserted resolution session, which is required by the law, and then a due process hearing. So, and I didn't do close to doing justice to her dissertation, but that can be located at the URL that I put below here. Now, if we go to the next slide, we have we've taken and put a number of these things into recommendations, but what I want to talk about is just for consideration. This was testimony of the late Jim Rosenfeld to the President's Commission on Excellence in Special Education, 2002. And what he said in testimony is there should and must be a wide variety of dispute resolution procedures available to both parties and school districts to use. Specifically, he talked about binding arbitration available upon election by both parties. And that's what Perry, of course, talked about. The American Association also talked about, and he ended by saying, I suspect many parents and schools would be willing to waive the rights of appeals from such decisions if binding arbitration were fair, impartial, and fast. Now, if we go to the next slide, one to end up real quickly talking about a few resolutions, and that is there we go. Require IEP facilitation. That should be a requirement. Many states are reporting that is a really good method for stopping conflict, for addressing conflict, because that's what it is. For improving communication, no attorneys present. Make mandatory mediation, or make mediation mandatory. Again, no attorneys present. One of the things that Dr. Balsley, Dr. Zuckel, and American Association do address is the problem of attorneys. That often it just brings conflict and adversarial nature to these. If mediation is not successful, resolution meeting is required, but no attorneys would be present. And we should require good faith efforts during mediation and the resolution sessions. If not completed in good faith, that factor would be considered in the next step, which would be state appoints an independent special ed content expert as an arbitrator to arbitrate this issue. So that model would be, again, required IEP facilitation, required mediation, required resolution session, which there already is, when no attorneys present, and then arbitration by state appointed special ed content expert, and with a very few cases, of course, the possibility of a due process hearing. So the next slide, David was going to bring up a few more recommendations.
Thanks, Mitch. I appreciate how you articulated that. And I want to make sure that we have just a few minutes for questions. I will refrain from talking my super fast way that I typically do when I do presentations. But what we have to think about is just some basic recommendations. And these are things that I have put together over just years and being part of this process. We do not come at this lightly, but we want to first streamline the procedures, make it easier for both parents and for school districts to actually present what's going on and talk about this. Because right now it's incredibly litigious. I've had due process hearings where I've had 3 feet of files that I've had to review stacked next to my desk. Keep that in mind. Increased transparency. about what the process really involves so that people can understand this and articulate this to parents and school districts so that we can encourage additional settlements, trying to understand what we do as a part of this. Next, enhanced training. I'm going through this quickly because I would like to get to some questions. Enhanced training for hearing officers. Hearing officers, the hearing officers that I have met who do first tier hearing officers, I applaud. They often go into sometimes, as I said, highlighted earlier, adversarial situations. And it's in a very emotional part of this process for some of these individuals. As a hearing officer, and I'd had things thrown at me. I had people rush at me, and luckily the court reporters electric cord tripped that person. So it's a very emotional thing, but I applaud all first tier hearing officers and I appreciate what they do. We in education need to do better with just improved communication. Many of us can handle anything as long as it's not a surprise. So the better we can do to improve services about where kids are actually functioning and how they're actually doing will do a better and help with what's going on as a part of this. But educators to prevent misunderstandings, resolve issues. Parental support and resources. I have parents who contact me from I think I'm getting right now 20 emails from parents a week. And what I typically try to do is put them in contact with their parent and training information center that is located within their state to help them as a part of this, because it's an important part of the process, and I want them to have a resource that's available for them. But we need to think about this and think about better, not just representation at IEP meetings, but better access to legal resources and assistance like this. I mean, there are some barriers in some of the states for bringing in outside counsels or outside parents on this. I mean, to get, you would think that there'd be reciprocity past the bar in one state that you could be able to be a lawyer in another state. That's not always the case. So there's some states who, as I said before, don't have this. Really want to emphasize alternative dispute resolutions. Encourage the use of mediation or other forms of alternative dispute to resolve conflicts without the need of a formal hearing. Just come together, let's solve this, and just try to figure out what this. And as a hearing officer, I didn't really have that opportunity to do that because we were about to go in and present cases. And we try to say, is there any way we can settle? And there often were, because it's often the first time that the individuals actually sat in a room and could actually move this forward. I applaud Dr. Sokel's push for a 45-day timeline on timely resolution. Ensure that hearings and decisions are conducted in a timely manner to avoid prolonged disruption to a student's education. Just get this done, move forward. These kids often are developing rather rapidly, and we need to do what we can to ensure that we're providing opportunities for them to move forward. Consistent application of the law. This was actually a big part of what I experienced when I was living in the Third Circuit. And I lived in the Third Circuit for several decades. Is I would have individuals who would come from other states where there was a different standard for what was expected for appropriate. This was highlighted very effectively in many of the amicus briefs as part of the Enders Supreme Court case in 2017. But we had very different applications of the law. I lived in Carlisle, Pennsylvania at the time, which was the home of the U.S. Army War College, and we would get colonels or colonels-to-be who had children with disabilities who would talk about how bad the experiences were in various states. I'm not going to highlight what those states are for you, but it was really interesting to hear how different the law was being applied and what was going on about this. We need to think about ensure that hearing decisions, that education expectations are consistent, but hearing decisions are consistent. Last two, feedback and evaluation system. Implement a system for feedback and evaluation of the hearing processes from all stakeholders to identify areas of improvement. What can we do to improve the process? What can we do as we think about this? What can we do as we discuss this? I'm more than happy to have conversations with individuals about how to do this and how to move this forward, but that's something we need to do. And last, technological integration. Utilize technology to make the process more efficient and accessible. Increasingly, many states have moved towards, but not all, have moved towards digital submission of documents. Zoom became a friend of many of us during COVID. So the opportunity for virtual hearings, so parents did not have to get childcare or leave their house and go to an unfriendly place. Just more online access to case status and decisions as a part of this. These are just some basic things. We'd love to continue this conversation. And I can't tell you how much I appreciate CADRE for what they do, but also for bringing this topic forward. And I appreciate the opportunity that I had talking with Dr. Reese about this in November. It was a wonderful conversation, and I look forward to continuing these conversations. I applaud all of you for thinking about these systems. I applaud all of you for paying attention to this. So the next slide lists contact information for Mitch and myself. This is my email address at AIR and Mitch's address at University of South Carolina. Yes, many of us are inundated with email, but if there's questions or concerns, things that we can continue this conversation, we would love to be a part of this, because we truly want to make sure that children eligible for special education resource and special education related services and their families get the opportunities to fully participate in their child's education. I'm going to turn it over to you, Dr. Reese. Thank you.
Oh, thank you so much. There were several questions that were posed, but I'm going to identify a couple that I think that can be answered very quickly. One, can these recommendations be implemented by an SEA within the current federal regulatory structure, particularly requiring alternative dispute resolution, state complaint before filing a due process hearing?
Mitch, you were going to say something also, or?
Oh, I was actually. As I've been looking through the chat, and one I noticed, and I have permission to use his name, but Lynn Beekman is on, and Lynn was actually mentioned in Perry's article, and he wrote a real cogent chat, something in the chat I want to just read. I've been doing hearings. This is again from Lynn Beekman. I've been doing hearings under IDEA since 1977. Most IHOs, independent hearing officers, then were not attorneys, as they are now. I was a new SPED law, having written our state's laws in 1971. We rarely had attorneys appear. Witnesses sat around the table. I swore everyone in, and I did almost all the questioning. Parties have always had the right to cross-examine under IDEA, and I provided that opportunity. I firmly believe we got to the truth with less acrimony, quicker and far cheaper than today's attorney-driven process. Most independent hearing officers, administrative law judges didn't even realize this format can still be used unless state laws would prohibit it. But they and some attorneys are not comfortable in having the ALJ or IHO performing this type of role. How about expressly allowing the parties to agree to this format under the IDEA? And that was just a suggestion by Lynn, and I think an excellent one. And really goes to answering a couple of the questions in the chat. Now, one of the things Dr. Reese just mentioned is, can these recommendations be implemented by an SEA? Well, as Lynn Beekman just said, yes, it can be. Now, a lot of the suggestions, including the arbitration, the requirement of IEP facilitation, would require some amendment to the IDEA. Additionally, state complaints are only addressed in the regulations. Dr. Balsley's suggestion that would require some sort of change either to state or federal law, preferably to federal. Okay, I just wanted to read Lynn Beekman's response.
And having received training from Lynn Beekman when I was working for the Office of Dispute Resolution in Pennsylvania, I really appreciated what he did. It was a wonderful session. Dr. Reese, we have the opportunity for one more quick one.
Actually, I think that we probably need to close.
Okay.
There's many comments about how valuable this was, and I want to make sure that folks see that the information in the chat for the survey is there. Please do fill out the survey link on this webinar. We are so grateful to both Dr. Bateman and Dr. Yell. You've given us plenty to ponder, and I want to again remind folks to fill out the survey. Your feedback's really important. And do stay tuned via the CADRE newsletter and our website for future webinars. And we are very grateful for your time and joining us today, and let us know how we can serve you in the future. So thank you again to both of you and for everybody for attending our webinar today. Take care.
Thank you.